Good evening, everyone. I am Omar Serrato, and that picture is Laura Neidigh.
Hello.
Um, she's not coming on camera tonight, and so that is what it is. But it's been a long time since we streamed together, and there was a ruling that came out with Bryan Freedman, and we haven't yet. Like I went on your live the other day to share my talking out of my ass comments about what's going on with David Gingras.
Yeah.
I'm going to expand on those comments and talk a little bit about what's going on with Friedman. I haven't visited this case, I mean, really since they submitted the MSJs or something like that. I don't know. It's been a long time since you and I talked about this case. It used to be a lot of fun. There's been a lot.
It's kind of settled down, and I'm not trying to push too much content when there's like nothing going on. You know what I mean? Because I'll burn out if I do that. So.
Oh, I think I'm already at burnout stage. You know what? I got burnt out talking politics with Brad. I think that broke me. My brain was broken after that whole conversation. I got so frustrated.
I just had to move on to some other things for a while.
Yeah, it was really affecting my mental health. I mean, not to say that my mental health is not affected by everything going on, but you know, I had to take a step back from all of those things because there were some harsh realities, revelations that came out of that conversation that I had to ruminate over and consider and process. Legitimately, my mental health was affected. Like I could not bring myself to stream. I just, I don't know, man. Mental health is really important. And I'm the kind of guy, when I get really passionate about a thing, it could become all encompassing and all consuming.
Yeah.
And get me, which is what happened. And so I've been gone for about a week, but now I'm back to talk about some more lighthearted stuff. Let's talk about some Justin Baldoni versus Blake Lively, Bryan Freedman drama. And there's not much drama. There's like the anti-SLAPP.
Yeah. Well, I mean, it's like a side case, you know what I mean? So like the lawsuit happened because of the Lively Baldoni dispute, because of what Bryan Freedman said in regards to that dispute, but it's like a side lawsuit. It's in LA Superior Court. Travis Flores' surviving spouse and his estates have sued Bryan Freedman himself. So,
yeah, well, I mean, the reason why this case even hit the radar was because there was some concern that Bryan Freedman would have to recuse himself from the case, or if he would get disqualified from the case. I mean, first off, he's not going to recuse himself. That's a judge's thing. Judges recuse themselves when they can't be fair and impartial or whatever, or to avoid the appearance of impropriety. The question was whether or not Bryan Freedman, by virtue of his involvement in this other case regarding Travis Flores, where Justin Baldoni was necessarily on the other side, whether or not that created a conflict of interest that would necessarily take him out of or disqualify him from representing Justin Baldoni in this case. The long story short of that is no, obviously that's not going to happen. And if that was going to be a thing, they would have that would have been dealt with long before where we're at now. We wouldn't be deciding that issue a couple of months before. When's the trial again? May? It's in May, right?
May 18th. Yeah.
May, gosh, it's 2 months away.
We're still waiting for the judge's rulings on the summary motions. So
that's going to come out on May 9th. I'm calling it.
That's fantastic. that works great for me.
How about that? So if you're unfamiliar, Travis Flores, he was a CF patient, community advocate. He appeared in Baldoni's My Last Days docuseries back in 2016. He shared ideas for a screenplay. It was titled 3 Feet Distance. It was focused on the CF experience. There was belief that Baldoni appropriated those ideas for 5 Feet Apart, which was another project that he had that came out back in 2019. He pursued litigation against Justin from like 2021 to 2022. He at the time was undergoing double lung transplants for the thing that he was suffering for. He had complications with it, and they ended up passing away shortly thereafter. And so this lawsuit is because his estate wants to continue on with the lawsuit. And interestingly, in that litigation, without getting too far into the weeds, it turns out that Friedman was on that case. He did very minimal research on it. He appeared to have produced a 0 work product on it,
right?
Which severely angered Travis Flores' family, or the purveyors of his estate, and they wanted to bring this malpractice claim against him. Also, defamation, invasion of privacy, whatever, breach of fiduciary duty, and malpractice claims.
So
we have
just to add there, though, the claims brought by the family, they never really brought this up until this potential defamation, which has now been thrown out on the anti-SLAPP. But this potential defamation came up. So Travis passed away, sadly in, I think it was like early 2024 or late 2024. I'm not sure. And then the Lively lawsuit was brought 7 or 8 months later. But this lawsuit with Flores and Baldoni ended sometime in 2022, I think, 2021, 2022. And so at the time, though, it was determined after looking at the facts and everything that was going back and forth between the lawyers that it was not possible, based on the timeline of events and when Baldoni's script was made and when people had communicated with each other, it was not possible for Baldoni's script for the movie to have been, using Flores's screenplay. So Bryan determined there was no way that was going to be successful. And so at that point, you can kind of say that it's responsible for the lawyer then not to take the money and continue bring the case forward when it's not, there's no way it's going to be successful, and to give them the advice to settle.
Yeah, it's an interesting case. I mean, because look, when your client dies, attorney-client privilege survives. Like, you can't talk shit about your clients, even when they're dead. That is the strength. That is the gravity of the attorney-client privilege. And so when he is making comments necessarily that were involving an underlying case of one of his former clients, that's where he potentially got into trouble. Is there merit to that? I don't know. Maybe, maybe not.
You know the quote, the statement they're referencing?
Yeah, I have it right here. Matter of fact, I had it written down. Do you have it pulled up? I have
the judgment pulled up for this.
Yeah, what was the statement? If you could read it for us.
Yeah, give me 1 second here if I can find I just need to find the block quote. Okay. It says, so Bryan said this during the Lively case when the press was asking him about the Flores case. Bryan said to the press, "In the copyright infringement case, I learned what great people Justin and Wayfarer were. I learned they did absolutely nothing wrong and there was no liability on their part whatsoever. As a result, the case was resolved without any liability on Justin's or Wayfarer's or any other defendant's part. This only further confirmed to me that Justin and Wayfarer are exceedingly honorable and highly ethical."
Exceedingly honorable, no liability on their part whatsoever. Those statements issued contemporaneously while Friedman was entering this case with Baldoni. It was problematic, but you could argue, obviously Friedman's saying that, look, man, I investigated myself. All I'm saying is, Baldoni's a good guy. He's exceedingly honorable. That was the language he used. There was no liability on their part whatsoever. Now that's problematic. Now the lawsuit brought against Baldoni when he was representing Travis, that was dismissed. That was dismissed. So when it's dismissed, there's usually, non-disclosure agreements. Let's not talk about the case, whatever.
It was a walk-away settlement, non-confidential walk-away settlement.
Okay. But when you make statements like there was no liability whatsoever to the other side, that's kind of towing the line between.
That's what the surviving spouse is obviously getting at. It's like you kind of attacked not necessarily, it's not like a direct attack on Travis's integrity, but they're kind of saying that the way you framed it makes it sound like Travis brought these non-meritorious claims, that didn't make sense. And it kind of makes
sense. He can't really go further than that, because what's he going to say is like, look, Travis thought some things in the very beginning, but upon my investigation, I found those things not to be true, and Travis was mistaken. Baldoni is exceedingly honorable. He had no liability whatsoever on his part. Is that shitting on the legacy of Travis? Not really.
Not directly.
Could you make the claim? Could you make the claim that it did?
It's more of an a matter of opinion, and you have to. That's like a personal response to that, and like everybody's going to kind of read statements and have their own opinions differently. So that's where I kind of get confused. I'm like, so he set the groundwork for somebody to possibly form an opinion that Travis, did something he shouldn't have done, but he doesn't outright say that. So that's where I'm kind of like, what is the law actually?
You want to know my opinion? I've lived in LA long enough. I've lived in California long enough where, hey, they were coming up on the Lively Baldoni case that was filed at the beginning of 2025. This lawsuit was filed around the same time, contemporaneously, basically. Bryan Freedman, high-profile lawyer, entering into the biggest celebrity case since Depp v. Heard. They viewed it as an opportunity for Travis's estate to cash in. So fuck it. Breach of fiduciary duty, breach of contract, malpractice, defamation, invasion of privacy. All of those things. Suing for all of those things. And way back when, approximately 6 months ago, I remember you and I talking about this very case. And the concern was, does this mean that Bryan Freedman is going to be disqualified? And I was like, nah, probably not. Probably not. And then, of course, Friedman files this anti-SLAPP suit, basically as a countersuit, and he gets it trimmed down. I don't believe for a second that Bryan Freedman expected the anti-SLAPP to knock out the entirety of the lawsuit against him. Matter of fact, he concedes certain things. Like, yeah, there's aspects about this lawsuit that are not free speech or speech protected, like namely the breach of contracts or breach of fiduciary duty stuff, whatever.
I mean, like malpractice related,
yeah, malpractice, all of those things. There's merit to that. You could bring that without saying that, without trampling on his free speech rights, basically. But defamation, invasion, those are specifically claims that cannot be carried on by the estate. Those have to be brought by the deceased, and the deceased can't bring those claims, and therefore those were kicked out. Full stop. There's no need for further inquiry. And so it's basically, it's a two-part analysis. Was it the lawsuit designed to trample on your free speech rights? In so many words, right? That's the first prong. The second prong was, if it is or if it isn't, is there even slight merit behind the claim such that there is a genuine dispute of fact for the trier of fact? And if yes, well then, defeat it. And therefore, I mean, look, you could argue a lot of things. And look, just without going into too many details, the allegations against Bryan Freedman was, look, we asked for the entire file. And when we got the entire file, there's only like a handful of documents in there, some bullshit around. We got billed like $80,000. I don't remember what they were billed, but some like astronomical amount of money. And when we looked in, there was like 5 pages or 5 documents that were, not generated by this firm. And they were a scant discovery, scant anything, whatever. And they charged us and they told us we didn't have a case, forced us to dismiss, and then shed all over Travis while saying nice things about Baldoni when he said them. That's the heart of it.
When it comes to the case file, I looked at the number of pages they said that they got from it, and I didn't realize, like, what does that include? Because I was very confused, because like, I'm pretty sure I paid for more pages than that in relation to the case. So I know it's not like 20 pages or something. What I mean?
They have legitimate. Now, look, my law firm is nowhere near the size of Bryan Freedman's firm. But when I have a case file, I literally have electronically stored. I build a file system like Top Sheet that's for all like the retainer agreement, the client's personal information. I'll have exhibits or potential evidence, and I'll have those categorized in a separate folder. I'll have pleadings in a separate folder, like pleadings and motions. I'll have declarations in a separate file. I will have minute orders in a separate file. I will have all of these things like discovery items, whatever. It's all categorized. And if I were to hand over an electronic file to somebody taking over the case, it's probably going to be somewhere next to, I don't know, 200 megabytes, 500 megabytes of stuff just with documents, sometimes bigger if there's like video files, media files, but it's substantial. Like if you were to print it all out, it's probably at least over 100 pages of documents, and that's for like a small-time family law case. So when you're talking about an entertainment law case, and by the way, my civil cases run far longer than that because the complaint itself is usually, between 30 to 50 pages on average or whatever, sometimes less, sometimes more. And then there's usually a countersuit or a response. And that alone takes up 100 pages. And then there's discovery that happens right off of the bat. There's all of the client's exhibits, and that takes up probably, usually in a case like that, where you're talking about material that may have been stolen, that's at least another 500 pages of stuff. And so if I'm taking over Freedman's case, I'm expecting at least 500 to 1,000 pages of documents that I'm going to be receiving from them. If I get like this scant file, I'm going to have questions as a lawyer. So where's the rest of it? Like, did you miss something? Because this doesn't look like what it should look like. And so
deal with that is because I guess I didn't read the plaintiff's response to the anti-SLAPP motion because I was like, I don't want to pay for that. I did now. Like, so I have it. I haven't read it, but I wanted to read more into that because it's like, what do you mean there were only like a couple dozen pages? It doesn't make sense at all.
What they're saying is, look, if you're going to advise, look, and I feel their pain because they hire this high profile attorney, Bryan Freedman. He's supposed to be the attorney to hire when you're in the Hollywood stratosphere litigating a case. So you're expecting like the tippity top of work product from him and his firm. And so you're expecting, and you're paying tens of thousands of dollars to even get the case off the ground. I forget what the retainer was, but I think they were pretty close to $100,000 in legal fees by the time the whole thing was said and done. And so they hire this attorney, they spend all of this money, and then a short time thereafter, without in their minds doing any of the due diligence, are convinced by Friedman to drop the case. And then they see him on TV with opposing party singing his praises. That would raise it.
There's like 3 or 4 years between those events, but yeah, and I think that, to me, if he had taken Baldoni's case right after that, I would be like, whoa, did you drop my case just to get business from him? You know what I mean? But like, this was a different timeline. But the thing is, with the due diligence and like looking into the case and all that, he could have kept the case going, and he could have charged them tens of thousands or hundreds of thousands more dollars to keep this going. But it took very little back and forth to discover that it was impossible for Travis's claims to be true based on the timeline of how things went down. And it was just easily provable that his claims were not going to succeed. And so like, what was he supposed to do at that point? Continue charging them for more business when like it was obvious that was not going to work? So, I mean, it's kind of like, would it be more unethical to like drop it then, or would it be more unethical to like keep going when you know there's nowhere it can go? It's
funny because like, there's another attorney we're going to talk about where that's exactly kind of what happened.
Well, we have a fake Laura Owens message, by the way, in the super chats. I don't know. Speaking of,
fake Laura Owens. I think the Baldoni case should be the only one you guys stream about. You do it so well. All the best.
I'm saying sometimes you think the Lord is giving you lemons. And in fact, he's giving you big, beautiful titties.
Oh, wow.
How's that for a proverb on a Wednesday night?
Okay. Holy shit.
Thank you, Laura Owens. Anyway, the point is, look, you're absolutely right. Because matter of fact, I just did it today. Where I told a client, like, I know you hired me to do this and I could pursue this further, but you don't have merit to your claims here. Like, I'm going to bring this motion in court. And look, I've researched it, and this is the evidence against you. But when I frame it that way, I will literally write a brief for them saying, this is what you presented me. This is what we have to prove. This is the evidence that they have, and this is their response. Based on my experience, my 12 years in family law, this is how I think this is going to go. I think that you got no chance at all at recovering under this. I think it's best to probably take this another route. If you really want to bring the motion, I will bill you. I'm just saying, don't say that you weren't warned, and here's this memo to prove that you've been properly advised and all the things that I've looked into to make that analysis. Now, did Friedman do that? It doesn't seem like he did. Does every attorney do that? Absolutely not. But I feel like in a world that is becoming ever more litigious, as an attorney, just to cover your own ass, you have to do that. If you're going to tell a client to dismiss the case, you have to memorialize why that decision was made. Because you're not going to.
I don't know because I don't know what was in that case file he handed over. I don't know if he did memorialize it or not.
I think you just said though that it was found out later that it was impossible for the claims to be true based on the timing.
Oh no, that was before they. I mean, that was before they dismissed the case. So I guess that would be the memorialization then. But those emails between the attorneys and the.
But if there was a letter like that they could point to and attach to the response, like, look, I didn't dismiss it because I was like, trying to woo Justin Baldoni as a client because he was this big celebrity, or I'm trying to get into the good graces of this higher earning potential clientele. That's not the point. Look, this was the legal basis for my decision, for my advice to them, and is what it is.
On that basis, based on that, he could probably potentially have those claims thrown out, just not by anti-SLAPP, right?
Yes, like a 12b6 motion for summary judgment. Absolutely. Anti-SLAPP is very specific to causes of action affecting speech. And just because they don't get thrown out for anti-SLAPP, it is a way to whittle down the lawsuit for sure. And they did. It got rid of invasion of privacy defamation pretty quick without having to even 12b6 it, which would have been a waste of time. I mean, they could have maybe also done that on demurrer, realistically, but they went the anti-SLAPP route, and I don't know if one is better than the other. I personally feel I disfavor demurrers. And by the way, a demurrer is just it's an attack on the pleadings, as in, even if assuming everything is true, it's defective on its face because they can't recover under these, because number one, the deceased is not here bringing the claims, and as we know, defamation and false invasion of privacy claims, the estate cannot bring those claims on behalf of the decedent. Could they have prevailed on demurrer? Maybe, but maybe it was worth it to, I don't know. It worked out. So they got those two causes of action kicked, and it doesn't forego their ability to 12b6 these things later on. Sure. Or if I know anything about Friedman, more than likely an MSJ. MSJs are better, in my opinion, because it wastes less time.
Yeah.
12b6 is a really good way to build a F out of your clients, which you can do. I mean, because look, thinking from an attorney's perspective, just billable hours. I'm going to bring in demurrer. He's going to probably charge $5,000 for that. Then he's going to bring an anti-SLAPP. He's going to probably charge $5,000 for that. And I'm talking normal people prices, not Hollywood prices. And then on top of that, we're going to bring in 12b6. There's another $7,500. And then after that, we're going to do an MSJ. That's another $10K before we even get to trial prep. Obviously, it's more. It is more lucrative for an attorney to file more motions. Yeah. When in reality, you could just handle these with just a MSJ or a simple whatever. And so, different styles. One is not better than the other, but one definitely makes more than the other.
Sure.
What do you think of that?
A lot of money for shit.
Yeah, lawyers are expensive, man. And
that's a lot of money.
Could I just a word of caution, man? I'm seeing it more and more. Because lawyers are so expensive, and I think you see it a lot more in family law. You get these AI pro pers where they
I've been seeing them.
Oh, we've never heard of anybody using ChatGPT for law, but you get these pro pers, and like they've done their ChatGPT research, and then they're like, "Hey, ChatGPT, could I get away with this, or could I do this, or could I ask for that?" And then ChatGPT goes, "Sure, absolutely, you can do that." And it gives them fake law, or like gives them this false angle and doesn't tell them the whole thing, and they have no idea what they're doing with AI research. Look, man, it's I don't even know how I got on this AI rant.
You were saying because lawyers are so expensive, you've been seeing a lot of that lately.
Oh yeah, people trying to cut corners. Don't cut corners with AI. It's the equivalent of representing yourself in court. I'll tell you what. This is what it's like.
I could represent myself way better than AI could represent me, and I'm not saying I would do well. I'm just saying I would do way better than an AI.
I would not deny that. What I would say, that AI is like this. Way back in 1996. Garry Kasparov was the greatest chess player who ever lived. And at that time, in 1996, chess computers had not advanced to the level where they were better than the best of the best human players. And so they had this tournament, they had this computer program, Deep Blue. And it was comprised of all these grandmasters trying to feed it moves or whatever and trying to get it to think like a computer to beat a human. Anyway, Deep Blue, it was the first time back in 1996 that a computer defeated the strongest human chess player, and it was a big deal. And since then, we're talking about 30 years ago.
When that happened.
Yeah, it's to the point where it's obvious when people are using engines to make their chess moves, and it's obvious in court to these judges and attorneys when you're using ChatGPT to make your chess moves, and all we got to do as litigators is take you straight out of book. Raise an issue that you have not ChatGPT'd. Just raise an issue that makes you uncomfortable that you cannot. Your Honor, I need to take a recess because I need to ChatGPT this. You don't get to do that, man. If you don't know the law, you don't know the law. If you don't know the nuances of it all, you're not going to know it. And all I got to do is take you out of book to draw you into the middle of the ocean and drown you in your lack of knowledge and expertise. It happens every single effing time. And so it has done exactly what I predicted it was going to do. It has made dumb people stupider in court. And it has made marginally smart people come into court with a false sense of confidence that is quickly destroyed within 30 seconds. All I got to do is like bring up one issue they had no idea was coming up. And then it's also the racist. Look, don't represent yourself in court, folks. There are certain things you can do that. There are definitely things that you shouldn't. And that's all I'm
I just, out of curiosity, because I know this case and I know Laura's case, like back and forth. I was from the beginning. I followed it. I read every single document, and I put some of this stuff into chat, and I like asked it some questions a couple times, and it gave me answers that I was like, but you didn't consider this or this or this, and I just felt like it was so stupid because I was like, you're giving me answers based on like you're not considering everything that's happened, because this ChatGPT thing, it can't possibly understand the nuances, and it can't possibly understand whether or not a human being is being truthful or not. You know what I mean? So it's like it's just stupid. Like it comes out really stupid, and I'm like, I could argue with it all day, but it'd be useless. So I don't really use ChatGPT unless I use it for two things. One, to find sources, so it's really good at referring me to sources where I need to go to look at the
research is good. Yeah, the research is fine.
Two, if I write some Karen-like message, like when I wrote my bar complaint, if I write some Karen-like message and I'm like, I don't want to submit this because I sound emotional and it's going to get in the way of my points, I'll put it through ChatGPT and I was like, can you make this sound like a rational person wrote it? So those are the two reasons I would use ChatGPT. So.
I'll tell you what, ChatGPT and whatever AI models, they're really bad, especially with a case like Owens. I mean, you're talking about 10 years of relevant facts in any one of those issues. It's not going to be able to parse through all of those at the same time. It'll individual issues here and there. And then what's funny is if you ask it the same question on different days, it'll give you different answers. And so it's like Russian roulette with what you're going to get. And sometimes the issues get so complex because they haven't been litigated and there's not really clear authority on the issue. And that happens a lot in family law, and specifically in the Owens case, that you're not going to get a good answer from GPT. You're going to think you're getting something worthwhile, right. And what you're really getting is a shot in the dark because they don't know either.
Yeah.
Anyway, moving right along, I guess the long and the short of it is, it was it's not that big of a deal that not the entire complaint from Friedman was kicked out with this anti-SLAPP stuff. It was very predictable what was going to happen, and the bar is so low for showing any merit whatsoever to support the claims. It's similar to some of the other stuff that we talked about, but it makes sense that the things that survived is breach of contract, malpractice, breach of fiduciary duty, and that they kicked out the other two. So logical. There's really nothing to write home about. And no, Bryan Freedman is not going to be disqualified as Baldoni's attorney. That's not happening.
Hey, Shizzy Wiznut's here. Hey, Shizzy, what's up?
What's up?
I love you too, by the way. He said I love you, and he put bacon in the chat. Thank you.
You have to have a real thoughts, and shit GPT is just garbage. Yeah, sometimes. Sometimes it is. Every now and then it gets something right. I mean, it's good for some stuff. It's really bad for others, is what I would say.
I don't think if there's anything else I use AI for where it's actually useful. And I think it's like making images. So like I made I probably shouldn't say who it was. I made an image of somebody who I was like, after Laura listens to this podcast that's out now, she's going to make like a voodoo finger puppet of you. And so I made the ChatGPT make a finger puppet of them. And like, that's something that I could use ChatGPT for. You know what I mean? It's just like random bullshit, but it's not like a serious matter that I need somebody else to write up for me. You know what I mean? It's just like stupid meme stuff. I don't use ChatGPT for like real functional things.
Well, you know what it's really good at, or AI in general, not necessarily GPT, but like organizing your files. Like if you got like a shit ton of stuff, it could organize it where it's like nice and neat. It could do a lot of the grunt work, but if you try to it's really good if you don't want it to think for you. If you just want it to do grunt work, that's, I think, the way where it really shines. I feel like, especially with content creators, like I feel like people that consume YouTube videos or social media content in general are so starved for human creativity. I feel like so much, like 80% of what you see out there is like AI generated slop. And it's like, you can tell, like you could tell by the syntax, like when people write their scripts, it's like, this thing happened. It was not about this. It wasn't about this. This was this. Peer this. Whatever. And they give you like this whole sermon. It's like, oh, okay, they got that from GPT, or they got that from.
To be honest, like sometimes I talk like that. And so that's my problem. People are like, this is Chat GPT. I was like, you bitch. I just talk like I'm just autistic. I don't know what you want me to say. Like that's
I've
just how
never in my whole life heard you ever talk like that on purpose.
not to you because I say weird stuff to you, but I mean like if I'm writing something for work or if I'm doing something academic, like that's kind of how I type. Let me see. I was trying to tell you, my cousin, she's a history PhD. She's a professor now at FSU, and she was like telling me the other day how like her students. It's very obvious when her students have used ChatGPT to answer these prompts based on these lectures. They're like she only puts out like 15 to 20-minute videos that she wants them to watch, and then they have to write up a paragraph response, and then ChatGPT will just totally fuck them because it'll say like some random stuff. So my cousin's name is Caroline Hackett, so she's Professor Hackett. And like one of her assignment comments she sent to me the other day because it was funny. She goes, "Unfortunately, I'm not sure what happened here. I don't know who Professor Chen is, but Professor Hackett says this isn't a valid response." So like it's just like people are getting so lazy, and I'm like, come on, man. Like I'm really glad that I went through school and all that, and even TAing when ChatGPT was not a huge thing because it's like people forget how to use their brains.
No, you're absolutely right. It's just I can't, man. I'm this. Look, I used to be really into creative writing. I used to like aspire to want to be a writer at one point in my life.
Yep.
And then when I hit when it's like people treat ChatGPT as a calculator, here, write this email to whatever, and it could have been done in like a sentence or two, and then I get like this 3-paragraph like overly formal AI SLAPP bullshit. I was like, get the fuck out of here, dude. It's like. I literally got one of these from an attorney the other day. It was literally like a meet and confer email, basically asking me to agree to a custody exchange location. It's like the email literally could have been this: "Hey, do you agree to have the exchanges in Corona?" And I would have been like, "Yes," and that would have been done, right? But what I got in that was like a 3-paragraph bullshit summarizing the entire case and the last hearing, and then at the very end of it, asking if I was okay with exchanges. Like, bro. Seriously? Yeah. I was so frustrated. I don't know. It's contributing to my negative mental health.
Just to test how this could function as a person. I'm gonna start putting our really weird personal conversations into chat and asking it to spit out a response, and I'll just like wait for you to figure out if it's ChatGPT or not. I'm not gonna tell you in advance.
Well, I think that's a good experiment.
If you get it wrong, you owe me $20. So
I am up for that challenge. Let's do it. All right. Should we talk about the one who should not be named?
Yeah, David
Gingras is the way you pronounce his name.
Is it Gingras? I thought it was Gingras.
He said gin like the drink, grass like the plants. Isn't that what he said?
Have I really been saying it wrong because I didn't even do that on purpose. Have I really been saying it wrong?
There's lots of it doesn't matter. It doesn't matter. I've been loath to want to cover this portion or his bar complaints or anything about him, really. It's just I'm really just not into that guy, man. He's an insufferable personality. And when I consider David Gingras, I view him from a very human perspective. I view him as a very broken man who is what he is. There's no healing with that guy. Maybe there is, maybe there isn't. But he's severely deficient in whatever it is that happened to him that causes him to have to be right, that causes him to have to like bloviate to his audiences and blogs, that causes him to have to constantly in the course of conversation elevate himself above you and keep you under his shoe. I feel like that's his MO. Like he has this very specific biorhythm where he will try to make you his friend. And the way that he tries to make you his friend is to impress upon you how important he was and how he's a First Amendment attorney and how he represented the dirty way back when and how he's been on Dr. Phil and he'll give you all of his accolades like you give a shit, right? And like he'll tell you about all of the famous people that he knows and all of the cool places that he's been and all the things that he could take you to or bring you to or whatever, but you won't know anything about the guy. And when I consider people like that, I was like, oh, this guy's a bullshitter. And in my own personal life, the second somebody starts talking to me like that, I write them off within the first 10 seconds and I never talk to them ever again if I could help it. Mm-hmm. Problem is I work in this profession and I'm forced to talk to those kinds of people. It's very much like Donald Trump. Like Donald Trump has always been that guy. He's like the bloviator, and he's constantly elevating his personality, and nobody does this better than me, and nobody builds better buildings, nobody writes better contracts, nobody builds better schools, nobody's a better negotiator than I. As soon as my first day in office, there will be no wars, and he goes on that whole thing. He's just a bullshitter, man. And then you kind of feel, you get a sense for that person, and within the first 30 seconds, if you have any brains, you immediately write that person off. The problem with him is he's got this obsessive personality where he feels that everybody he comes into contact with, he tries to force them into these interactions. And it's gotten him in a lot of trouble. It's probably gotten him far to a certain extent, but now he ran into a perfect storm with this Laura Owens case.
Yeah.
And number one, he was ill prepared. And I think he's admitted that over and over with this case, that he was the guy coming in, he didn't know anything. And there was like 7 years of evidence that was going into, that was necessarily relevant with respect to the Eckert trial back in June of 24. And he's trying to play catch up, and he had 3 months to do it, and he was not prepared. Did he purposely put on evidence that he knew was false? And that's one of the claims that the bar is making. And they got their reasons for saying that. And, you know, he's done a lot of other things. I don't get into all the reasons why they are mad at him. It's not just about the free speech stuff, right? If it was just about the free speech stuff, this would be over.
Before we, get too far into this, there's going to be like, with all the phone calls he said he's had with this guy, and I'm sure tons and tons of emails, there's going to be a lot of shit that he said that we don't even know about. And it's probably worse than the stuff we do know.
I don't want to, if I consider David Gingras objectively, I'm not here to like dump on David Gingras, whatever his personality flaws. I mean, hell, I'm weird in public too. Sometimes I do some stupid shit. I'm not the perfect guy. Yeah. I mean, look, everybody's got everyone's got their social faux pas, man. It is what it is. And so, one of his is, and it's maybe it's not even maybe it's not him. Maybe it's me. I don't like to talk to you on the phone if I could avoid it. But the first thing that he does, like when I was involved in the case with him, is he wants to get on the phone and have a whole hour conversation. I'm trying to pick up my girls from school, or he got things to do. It's like, hey, put this in an email. I'll respond in the morning. And he gets really upset if you don't respond to him right away. The second that you do not agree with his position, and he knows that he's not going to get one over, it was different. I noticed it was decidedly different with this guy that he went up against with Rob's case. Because objectively speaking, David in that case with Rob kicked that guy's ass like 10 ways to Sunday.
That guy was like a meek and like did nothing.
He was ill prepared. He didn't have the personality style. He didn't have the charisma to be able to stand there and hold a candle to David Gingras, who thrives on that stuff, who's been sitting with the facts of this case for a couple of years. And so it was a mismatch in terms of personality, but it was more of a mismatch in terms of he had no control over the facts to be able to push back on the things that were coming at him in real time at that trial. And as a result, he got destroyed. And he opposed David Gingras. And I'd imagine they weren't having these friendly conversations, but David won. And so he doesn't have any ill will towards that guy. But if it's perceived that the general public favors somebody over him, then all of a sudden they become public enemy number one. It happened with all of the people that have ever spoken a negative word against Gingras. And he'll start out with like, I don't care if people talk about me, but I do care about them. And they're all dead to me. And he'll go back and forth, and he'll do these things.
He said people were dead to him before he ever spoke a fucking word to us or listened to people speak a word. It was just based on the word of Laura Owens. And I was like, lawyers have to vet their clients to like make sure their client is reasonable before they come out swinging like that. Like it's just ridiculous.
Well, I was dead to him because I viciously attacked his legal position after Rule 26. And then I was dead to him.
He really liked you for a while there. I remember I was like, dude, you guys have like a bromance or something. You stuck up for him on Twitter when people were saying he did something that he didn't. You were like, no, that's not what happened. I mean, you really went out of your way.
I mean, I stick up for people all the time, even when I don't like them. I've stuck up for him with some of this bar stuff. Like, it makes sense. Some of the things that he's saying is like, hey, if there's a factual dispute with some of the things about Mata, then he should be able to depose her, I guess. And then if he's got, my only thing was, if they're saying he needs a court order to get a deposition, and he was trying to claim that the deposition was the court order, well, then just go get a court order then to get the court order that would allow him to depose. do the thing, like go through the processes.
I think his problem with the factual disputes now is going to be like he gave his answer where you're supposed to say yes, no, or I don't have sufficient information. Basically, you're supposed to answer that with like up to 3-word answers in an answer like that.
Went
in there and like gave like factual conclusions, and then also like went into arguments that he wasn't supposed to go into. And I feel like he basically just made himself look unreasonable to a judge who's going to look at that and rule based on the I admit this, but not based on the arguments that he made in the answer, because that's not where that belongs.
By the way, Cynical Chief with $2, thank you so much for that, says David Gingras now has 2 types of bar troubles. Oh. Does that statue look like Logan Roy on Succession? I've been rewatching that show.
What does that look like to me? Oh, God. Who was the guy who played Zeus in Thor? Love and Thunder, right? It was Love and Thunder.
Arnold Schwarzenegger?
No, it wasn't Love and Thunder. Which one was it?
Didn't he play Thor?
I don't know. He looks like
the stream, Lauren, with your gay.
Okay, why am I gay for loving Thor? That's like the least gay thing I've done in a long time.
Because I was raised in the 90s and everything was gay in the 90s. So. Oh, anyway, what was I even talking about, man?
There's a bar comments in the super chat.
Oh, excuse me as I hack up along. Crow. Oh, Russell Crowe? No
Russell
way.
Crowe. He didn't look like Russell Crowe.
Russell Crowe did not play Thor.
No. He didn't play Thor, but that's what the statue looks like. They're saying. Does he? Hang on.
Anyway, I think I was saying that I don't have a problem defending David Gingras, even if I don't like the guy. I guess the truth is I don't consider David Gingras. He's not important to me. He's not relevant in my life. And so in spite of his feelings for me, I could look at his case objectively and decide that, hey, he's kind of got a point there. I mean, evidentially, why shouldn't he be able to depose Judge Mata? You know, what's the big deal with that? If there's rules or laws preventing it, then write the motions and litigate it. But just if the way that they litigate these bar cases, and I've never been involved with one, but if the way they do it is if they are beholden to the rules of civil procedure or the federal rules of civil procedure, then he should be allowed to ask questions and make inquiries. What's wrong with that?
Well, so I think that it's not unreasonable if this were to move forward for him to depose Judge Mata. What I think is unreasonable is that he continues to put like public warnings about her on the website, accuse her of
that is problematic. You're right. You're right about that.
Like having her process server stalk her at the courthouse, even after she says like, have the AG's office served, because the AG is going to be representing her there, Pam or whatever her name is. Like, have her served, like, so he could serve the subpoena to the AG, and he's like, Mata's evading service. She's committing more crimes. And then, like, texting her father is fucking nuts. Texting her father is nuts.
Yeah.
And then writing a letter to his house is fucking nuts. It's scary. It's harassing and it's scary.
I think we should go through a timeline of events with Gingras. This is what I found with respect to him. It's not his first rodeo with being disciplined by Arizona. There was another case where the underlying conduct, it wasn't stated in a public order, but he got suspended for 30 days. I don't know specifically what he did, but he was suspended for 30 days for doing something. In April of 2008, the Arizona Supreme Court issues a judgment order saying he's suspended. He's placed on 2 years probation. Mm-hmm. He's required to do stuff. He was supposed to abstain from alcohol or whatever. Submit to biological fluid testing, which is wild.
I've never heard of that.
Engage in therapeutic counseling. And those terms couldn't be modified without prior court approval. He was ordered once to pay $7,125 in disciplinary proceeding costs. That included a flat administrative fee. There was expenses with that. Anyway, that was his prior engagement with the bar. So obviously, March of 24, he begins repping Laura Owens. Mm-hmm. April, he files this response to Woodnick's motion, attaching Dr. Dean's expert report that we're all familiar with. That was not under seal. That finally becomes...
Publish that online.
Yeah, that became the basis for bar complaints by Womack and Dr. Dean's. Gingras is saying that Mata never ordered sealing, or that it was somehow unsealed or already shared after it was sealed. I don't understand his argument. And I read what he said once. I just forgot specifically, but he's saying for whatever reason shouldn't have been sealed, even if it was sealed, or what he did was fine. Obviously, he's arguing that.
Yeah.
Gingras, what I'm really familiar with is on June 10th, he threatens to have Maricini arrested. My client, Michael Maricini, because he complied with a subpoena.
Let me ask you a question about the subpoena.
Yeah.
So the subpoena was served from Arizona, right? And then I've seen his arguments that it's not a valid or enforceable.
It wasn't a valid. He's right. I know where you're going with that.
Right.
It was not a valid, enforceable subpoena. He's absolutely right with that. In other words, like there were witnesses that if I needed to subpoena them in in Arizona, I guess. Like for example, Clayton Ecker was going to be one of my witnesses.
Right.
He resided in Arizona. Woodnick was going to be one of my witnesses. He resided in Arizona. I would have had to get permission from Arizona to get an out-of-state subpoena to be effective and enforceable in California court with respect to somebody in Arizona.
Okay.
I didn't do those things because they were friendly witnesses. They were coming anyway. They said,
right.
I asked them, do I need to subpoena you or do you want me to subpoena you? They're like, no, we're good. I'll show up. All right, cool. So that was that. And that's kind of, I suspect, what happened with Mike's case. Like they issued a subpoena, but he didn't go through the formalities of requesting permission from California court to make it enforceable in Arizona because it was a friendly witness. He didn't need to force or compel.
My question also, I guess the second part of my question is Mike reasonably expected to know that a subpoena from Arizona is not enforceable? He's not an attorney. So like, is he reasonably expected to know that he doesn't have to comply with that subpoena, or is it reasonable for him to see a subpoena and be like, oh shit, I have to show up at court?
That question is really nuanced. If he was issued a subpoena, even if it's not technically enforceable and he shows up because of the subpoena and he believed and appeared and didn't challenge the validity of the subpoena because he didn't know to challenge the validity of the subpoena, you saw that with the Lively case, right? They demanded things from that lady and like cornered her and like took her phone and all that kind of stuff. I'm forgetting names already.
Yeah, Jen.
Yeah, and she didn't know to challenge it. Well, if you get issued a subpoena and you don't know that it's not enforceable because they didn't do this formality,
right.
And you show up to court, then yeah, you're not acting in bad faith and very unlikely to have anything happen to you. But the biggest issue with what happened on the 10th is that the issue of Maricini's appearance was previously discussed.
Right.
Not just that day. It was discussed between the attorneys.
Right.
And there was multiple threats or communications made by Gingras saying that if you show up, you're going to be in violation of a court order. And if you don't want to talk to me, then I'm just going to have you arrested, or saying something to that effect. But if you do talk to me, I'll agree that you're not in violation of anything. Honestly, I don't remember if he said that to Woodnick or he said that to Maricini or to somebody else, but there was emails to that effect. And so don't hold me to the fire about the
I know what you're talking about, yeah.
accuracy of those statements. But just off the top of my head, there were those threats that were being made. So he was basically having communication with a potential witness, agreeing that he wouldn't be in violation of anything, but he had to answer David's questions or agree to be questions. And the fact of the matter was he could have just deposed him.
That's what I was going to ask. I was like, could he not have, if he really needed that, could
he
not
had
have
time to depose him? He could have had a deposition. He could have had it done within 10 days. He was on the case for 3 months. He could have served a deposition and had it within a couple of weeks, and it could have been done via Zoom, and he would have been forced to answer David's questions, and it would have been not a thing. He didn't have to voluntarily
not to do that.
Yeah, he didn't have to voluntarily have a phone call with David Gingras just because he really wants answers to certain questions.
No more than Judge Mata's father does.
Yeah, it was David's bad for not issuing a deposition. Just depose him then. He's going to depose Judge Mata.
I swear that he mentioned either in tweets or blog posts or something that he could have Mike deposed, but he chose not to have Mike deposed.
That's his decision. Then he's got to live with his decision. But what he doesn't get to do is intimidate a witness by suggesting that if he doesn't talk to David Gingras, he's going to be arrested if he shows up on the day of trial as a witness in a trial involving the Ecker case.
Yeah.
And so what happens is they have those prior email communications. And then on the day of, my understanding of it, obviously I wasn't there, but my understanding of it was, and the only way it makes sense to me as an attorney, because I've literally had these discussions in the California case with my judge, Judge Gold. is that they addressed the issue of Gingras's concern with the violation of the DVRO, and the judge said, "Look, I got a bailiff here. We got people in the audience that are disguised as public people, but they're really security guards or law enforcement or whatever. She's in a secure location. My courtroom is safe. It's not going to be an issue. He's allowed to be here at the trial."
Yeah.
And so upon that finding and the judge saying that, Gingras wasn't happy with it. Now, I don't know the timeline of events between whether he called the cops after that conversation or prior to that conversation, but that's pretty important. And I don't know heads or tails which is which. I just know that the law enforcement was called. I don't know if he had like heat-seeking missile drug-sniffing dogs called or the FBI was called. I don't think that was true. But law enforcement was certainly called. And there was certainly an attempt to, in my estimation, I can't view that as anything less than attempted intimidation of a witness, which is of itself a crime.
Right. Yeah.
If we're going to get technical about it, I mean, if we're going to like cite the guy for jaywalking, I mean, technically that is a crime.
I don't think that any reasonable attorney, in my opinion, would have done that. And I know that Laura wanted him to do that, but like still any reasonable attorney who was representing Laura, like say Corey Keith was still representing Laura, I sincerely doubt that he would have done that. I can't imagine a reasonable attorney would act that way.
I've never in 12 years of practice ever had it suggested to me that the protected party or the person against whom the restraining order was filed being present for testimony while the protected party was also present was in violation of a DVRO. That has never been suggested to me. It's never been litigated. It's never been until I got involved with this Laura Owens case. It's never even been brought up. And when it was brought up by Laura Owens herself in court at the hearing prior to, I don't remember if it was prior to October trial or the November one. But Laura tried to say that, look, I want to testify via Zoom because there's people that I have protective orders against and I'm fear for my safety. And the judge shot it down. It's like, you're safe in my courtroom. And she had a preview for that argument because David had filed all of his stuff in our case. And she basically said, I know what you're going to say without saying, I know what you're going to say. You're safe in my courtroom. He's allowed to be here. He's a witness. They are witnesses. I got a bailiff. We could have them out in the hall while you're in here. We could have them only come into the courtroom while they're testifying, then necessarily leave or whatever. But there's no issue with them being here. You still have to be present. That's not an excuse. And I'm not going to say that they're in violation of anything by them coming as a witness.
One of the most telling things about how performative it is that they complain so much about Mike being there is that she allegedly, per his recount of things, panicked so much just by seeing Maricini close to her, yet she has orders against Clayton and Greg. And yes, Clayton and Greg could be there because they were, like Clayton, it was his case, and Greg did have a subpoena from Arizona, which was enforceable. And so, she didn't say a goddamn word about how scared she was to be around them, but she did about Mike because she thought that she could use that to get him arrested.
I can't even disagree. I mean, normally I would say that's far-fetched, but I can't disagree with what you just said.
We're dealing with someone who's extremely calculated, and everything points to that. Literally not a single thing about Greg being in that courtroom. I've never heard them complain about Greg being in that courtroom once because he had an enforceable subpoena. They're only complaining about Mike's because they think that they can weaponize.
I do believe that Laura complained about Greg being there.
When did she complain about that?
I don't remember. I just feel like I remember that, and maybe I'm misremembering. I just feel like I
only remember her saying she was scared because of Mike.
Maybe it was after the hearing. Well, definitely the June hearing. I think that Mike was the big issue.
She called the police on all three of them after the hearing, but it was because of an Instagram, not because she was scared at the courtroom.
I just feel like I've heard. I don't know. I don't want to speak out of turn, but I feel like I might have. I think I heard her complain about that before.
I mean, there's a lot of shit to remember.
Hey, you got a super chat. You should read it.
Ronnie G, thank you for the $5. How is an anti-SLAPP a thing against the bar for an investigation or against someone reporting him to the bar? Well, I guess lawyers, my layperson opinion before Omar tells you the real deal is that lawyers they have free speech too, but some of the things that lawyers say they can be held accountable for within the scope of their job. Like you can't undermine judicial proceedings or like the judicial process as in your capacity as an attorney. So writing a public warning against a judge and your law firm blog is obviously a problem that your employer, aka the state bar, I guess he's not like an employer, but the governing body of your profession should be able to punish you for. But he thinks anti-SLAPP is like this big sweeping excuse for everything. And if he had said like, I think Judge Mata misapplied the law, I think Judge Mata did XYZ wrong, it would be one thing. But he's out here saying she did a federal crime. And so it's different.
Well, and while they were still in judicial proceedings, basically, he was shitting all over Mata and posting it on his blog. That's a big deal. That has nothing to do with fair speech. That has nothing to do with free speech. That is not a free speech issue. What that is interfering with a trial, publicly preventing a fair proceeding, or basically attempting to prejudice the proceedings by speaking out negatively against a judge. You can't do that. You just can't. You can't. Anyway, what I understand he's up for is the following. There's 7 different ethics rules at issue. There's ER 3.3, candor to the tribunal prohibits false statements of fact or law to a court, prohibits presenting evidence the lawyer knows is false. He's going to have to answer questions about that. Nothing about that has anything to do with free speech. Fairness to opposing party and counsel. It prohibits the unlawfully obstructing opposing parties' access to evidence, prohibits frivolous or harassing attacks. That has nothing to do with free speech. Trial publicity. What we just talked about, it prohibits extrajudicial statements that a reasonable person would expect to materially prejudice a proceeding, like saying that a judge was compromised while we're waiting for a judicial opinion from that judge. That's not an issue of free speech. Respect for the rights of third persons. It prohibits using means that have no substantial purpose other to embarrass, delay, or burden third parties. And that could arguably be about free speech, but it also is about conduct as an attorney. You shouldn't just be shitting all over third persons for no reason, with no substantial purpose other than to embarrass, delay, or burden third parties, such as some of the things that has given rise to the many bar complaints against him.
Mm-hmm.
That's less to me about free speech than it is about conduct.
And so, his like recent posts, which there are many, but in his recent posts, he's said, and this doesn't cross the line, but he still hints at it. He's like, if the judge in this case, this bar case, is fair, I'll win, and if I don't, well, it's because she's not fair. Or he's not fair. I'm like, dude, don't do this. Do not do this.
I mean, I wouldn't say that. I would not say that if I was trying to save my bar license. Right. If that's the thing that they were concerned about, I certainly would not be commenting on the judges. However innocent I thought it was, I would STF you about the whole thing until it was over, as I have done in other cases I've been involved in.
I know he said that Mark Randazzo is going to help him with the anti-SLAPP stuff because as much as I don't want to like watch his videos and stuff, I have asked people about like, oh, what is he saying? Because when there was a clip about, I think there was a clip about you, a clip about me, so I had someone send me that. But like, I heard that he was having Mark Randazzo help him with his anti-SLAPP part, and so I'm like, you really need a lawyer who's going to help you with this whole thing. Like, he really, really should have had a lawyer write his answer for him. Like, his answer was full of arguments over like irrelevant, rambling shit, like whether or not sonograms are relevant to paternity proceedings. I was like, you just fucked yourself.
Yeah, a guy like David is look, he's an awful witness. He's a good attorney. He's an awful witness, just because he gets on these waves of consciousness that he just has to get out, and he has no ability to censor himself.
No.
As you've seen in some of his stuff. And so it would have been a really good idea to have an attorney write his response for him. I agree with that, or at least water it down or tone it down or show that he has the ability to play between the lines without, towing the line maybe, or going a little bit over. I don't know, man. There's lots of decisions that
I want him to have a fair proceeding. I want him to have a totally fair proceeding, and I don't want there to be any reason for him to come out and be like, everyone was unfair. Everyone's committing crimes against me. You know what I mean? And so I'm like, please get a fucking lawyer.
Yeah. Well, I mean, I can't help him there, man. I think if he was talking to a pro per, he would tell them the same thing. You need me to speak for you. And then which would be fair because at least that way he could speak objectively as a non-party and, argue the finer points of the law and get as animated as he needs to without being in danger of ethical violations. And so, what is this? Only interrupting old, early Letterman episodes for Z, Lauren, and Omar. Why are they calling you Z, Lauren?
No, it's just a typo.
Your mom's a typo.
Sometimes I feel that way. Yeah.
My mom's a typo. We're all typos. What are the other two? The other one was 8.2. It prohibits false statements about a judge's qualifications or integrity. That's a big one.
Mm-hmm.
That's not a free speech issue. That is an ethics issue. There's a difference between free speech and ethics. There's a difference between free speech and conduct. And so I just think I personally think it's a mistake to take the anti-SLAPP route when clearly what the complaint is about, just looking at the things that they have issue with, appear to be ethical conduct violations. 8.4 is the last one. It prohibits conduct prejudicial to the administration of justice. And that's more of a less catch-all. And so, it's funny. The last two bar entries of Gingras I read, he said that everything was moving really fast. And he was getting frustrated.
He's answering right away, impulsively. I'm like, you could take like 10 days to answer this shit. And you're doing it now.
There were times in the Owens case where I wrote like a whole response to things. And then I would send it to Rachel just to get it off my chest. And then she would tell me not to send that thing. It's like, you're right. I will not send that thing. I'm going to stay quiet. It is a really valuable thing to have, just somebody on your side, a friend, a buddy, or whatever, a coworker, whatever. Just if there's something that you really got to say, just get off your chest. I tell my clients to do this. If you really want to say that in your declaration, then send it to me first. I will edit it and you'll feel better. And then we'll say what we should be saying.
Right.
The non-emotional version of that. Right.
Yeah.
And I think that David's fatal flaw is he has no ability to disconnect his emotions from these cases, specifically with respect to this one. And I don't know what it is. I've never seen anything like it. Yeah. There were times, in spite of my back and forth with David, that I feel sorry for the guy sometimes. And it's I forget about all of the bullshit that he's pulled against me, against like Dave Neal, against you, against Rachel, because, water under the bridge. It's over. Done. I've moved on. Life moved on. He is who he is. He's dealing with this now. It's a consequence of his conduct. And I do sympathize because some of his arguments, I can see where they have merit. At least if he just wants to ask questions, I can't get over the Mata one. Like, if he wants to depose her and ask questions, I don't understand why he wouldn't be able to do that if there is a legitimate dispute of facts. On the other hand, if there is not a dispute of facts, then I guess there wouldn't be any reason to, wouldn't be relevant. We could stipulate to it. Matter of fact, it's one of Gingras's moves. It's like, Your Honor, I will stipulate to the fact that Laura Owens was once found to be non-credible in a family law case out in Arizona, Maricopa County on June 10th of 2024. There was findings and she was referred to the DA's office for prosecution. I stipulate to that. We don't have to talk about it. That's a way of silencing all of the talking points that would prejudice her and entering it in a way that is the most safe. And so, I don't know. He doesn't have an ability to do that. He always throws in a little bit extra. He can't control himself.
Well, it's like he's always on the offense and he needs to defend himself or his client, and he's always on the offense. And I'm like, at some point you gotta stop that and be like, what's the best thing from a defensive perspective? What can we say here that's not gonna like open my client or myself to further harm? And he's not good at that because all he cares about, I think he sees red, and all he cares about is attack. Like accusing Greg Woodnick and Dr. Deans of lying in his answer document. In this, like, that's fucking insane. I'm like, you're always on the offense to the point where it's like you're ruining your life.
I don't know, man. He's I don't know. I have lots of opinions about him, and I've been saying for a long time, he's like a dying star. He's just imploding in on himself.
Mhm.
And it's just wild to me. Like he found it, like he was living his life as a First Amendment attorney, and like this quasi celebrity attorney or whatever, handling these cases, the dirty Dr. Phil appearances, probably had a relatively well-paying gig out there as an attorney in Arizona, dually barred in California and Arizona. And then he runs into this Laura Owens case. Why did he take the case? I couldn't tell you. I've had conversations with him about it actually when we were both friendly. I mean, I'm not going to get into it. I couldn't tell you why he took the Laura Owens case. I don't know why his red flag meter didn't go up looking at some of this evidence as it would any normal attorney, as it did multiple attorneys before him. But he is, for whatever reason, dying on the Laura Owens hill.
Yeah.
And I am astonished at how it has led him from the 2024 verdict to Laura Owens getting indicted to him being brought up for disciplinary proceedings before the bar, where he's facing expulsion from the Arizona State Bar. Either this was pre-planned and he just doesn't give a shit. He's going to retire anyway. Who cares? Whatever.
Yeah.
It's fun to talk about. He's having a good time with it. He enjoys the notoriety it brings. Maybe there's something to that. He's going to get disbarred. He's going to fuck off to Italy or somewhere, or to Europe, or wherever he decides to move.
I mean, if you got the funds, you might as well.
You know what? That's not a bad plan. It's not a bad plan. If he gets disbarred over here, he leaves in disgrace and he has his fun and he goes to Italy or to Europe.
In Europe. You know what I mean? Like, nobody's going to care about this in Europe.
Well, that's what I mean. He could be anonymous and he could still every now and then troll people from JFC in opportune times from all the way over there. Maybe it's just it's an enjoyable thing for him to do. I don't know, man. I could tell you this. If his defense of all of this stuff is a First Amendment defense and he's citing the ex parte Young case as a basis for potential federal court intervention, that they're going to somehow intervene in the state bar proceedings because this is an affront to his First Amendment protection. It's not a First Amendment case because the First Amendment does not immunize attorneys from acting or conducting themselves the way that he has. You're not immunized from being ethical. You're not immunized from abiding by the rules of professional conduct. There's the Arizona State Bar. It's not there to litigate against attorneys for First Amendment issues. It's there to litigate against conduct and ethics. And it's supposed to be to protect the general public from bad acting attorneys. Yeah. Regardless. And you could, by the way, you can say a lot of shit that's protected under the First Amendment, but not when you're the attorney. Not if you want to stay an attorney. Like if I were to jump on this, look, I got court on Friday. I got a motion I got to argue. If I just jump on right now and start talking shit about that judge, about how unfair they are, and about like how biased they are, and about like what a piece of shit they are, and all that kind of stuff, I'm certain that I would be referred to the bar for misconduct. Yeah. And so, look, it's a double-edged sword, or it's not a double-edged sword. It's a single-edged sword. He's trying to make it a double-edged sword. And I found this to be David Gingras' style. He tries to insert mundane legal arguments, not mundane, obscure legal arguments to try to intervene and muddy the waters. Mm-hmm. And I view this First Amendment defense of his as nothing more than an attempt to muddy the waters and to detract from the main issues. He did that in Mike's case. All of that intervention bullshit, he knew there was no legal validity to those motions. He made some obscure legal argument. He tried to piece together some cogent argument, and it was easily destroyed to the point where the judge called it a clown show or a sideshow or whatever.
Oh, no, I thought everything he said it made perfect sense.
Maybe it did.
Yeah, right down to the pictures of me.
And he doesn't want the smoke and all of that. And look,
that was insane. That was insane.
I viewed all of that as, number one, he found an obscure legal argument to try to interfere or interject his perspective in the case where he wasn't representing her, but he could do the side argument and muddy the waters, and the judge didn't care. All it really did, in my opinion, is preview to the judge how ridiculous some of their arguments were going to be, and how we were going to take them down at trial, and honestly acted as like miniature trial briefs when they weren't framed that way. I was literally just responding to David's stuff. He wrote it like in the form of like a trial brief. That's honestly kind of what he did with some of those things.
If you want to be a successful attorney to some extent, and I know like some more than others, but to some extent you have to care what your peers or like other professionals in the legal profession are going to think about you and your writing. And he just doesn't. He's just kind of like, fuck it. I have this goal in mind. I want to attack these people. I'm going to go for it. I don't care what anybody says. I'm right.
I'll give you my honest assessment of Gingras's writing.
Oh,
he's not a bad writer. He definitely has writing talents. It's just misplaced in the way that he deploys it. And look, if he was like a 5th year or 7th year attorney or 10th year attorney, his writing style, I'm guessing, would probably be a lot different, or maybe it's not. Maybe he's always been an asshole in his writing. But the way that he comes off, like he's developed, like every time he disagrees with a point, he first of all, you're not a 25-year veteran attorney. You're not a free speech lawyer. Like one of the things that he said about me in that little clip he made about me was, how dare you come in on this case? You're not a First Amendment attorney. You've never tried a First Amendment issue. And it's like, dipshit, it's not that complicated. The First Amendment is really not that complex. I read the same cases you did. If I wanted to do a First Amendment speech, look, the first trial that I ever did, literally the very first jury trial I ever did, was back in 2016. It was a criminal case. And the attorney that I went up against was a 20-year vet. I think I'd been practicing for 2 years, and it was my very first trial. Did I know the law as well as that guy? No. Did I have the experience that the guy did? Hell no. They got probably done like over 100 jury trials, and I was on my first. It was my maiden voyage. But I won the fucking thing. I won the trial because the law's not that complicated. The law, it depends on much more than stating that I've been an attorney for X amount of years, and therefore I'm more believable than you. It requires being able to catch the correct wave of influence for the trier of fact, being it the judge or the jury, and being more trusted than the other side. Gingras pulled that off in the Hey Rob case, but he came out looking like an idiot in my case of Maricini as the intervener. And when it came to him against Woodnick in the Eckert case, and these are my only points of reference for him, I've never seen him in action anywhere else, because his side was full of all of these bombs of false evidence and perjury and all these other things that were going on. He was not the most trusted guy in the room, and Woodnick wiped the floor with him because he was the more believable. He came off as more credible. And ultimately, when it comes to the practice of law, all that really matters, it's not how long you've been practicing. It is your ability to convey to the trier of fact that you are more credible than the other side. If you're more credible, then you are the one to be believed. When there is a dispute as to law and you give your opinion versus the other, if you're the one that is more credible, they will believe your side. You will prevail more often than not. That's all it is, man. That's the secret to practicing law. You can't get that off of ChatGPT.
Yeah.
That is a skill that comes from practice. It comes from conviction. It comes from believing in your case. And it honestly, just to put it bluntly, it comes from having a professional ethics about you, that you care about the truth and you care about the letter of the law and you care about not just winning, you care about getting to the right conclusion. And I feel like there might have been a time where Gingras believed in those things. There's a reason why he's been around for 25 years, but at some point, somewhere down the road, he lost his way. He's got a long, rich history of misconduct, and I'm not going to go through every stupid little thing that he's done. Sure. Does he have a criminal record? Yes. Has he been disciplined by the bar before? Yes. Is he altogether an evil, rotten person? That's up to you to decide. But right now,
me. Up to someone else.
The way that he's conducted himself in these proceedings, I'm just saying that the First Amendment defense is not going to rule the day if the issues they're trying to decide is whether or not he conducted himself appropriately or ethically based on those 7 rules. And so that's all I really got. I'm not going to read. I'm not going to do the Laura Neidigh stream where I read word for word the
Oh
complaints.
God, I'm so tired from
I don't
that.
know how you do that. I'm just going to, that's what I have to say about it. And I'm just going to leave it at that.
Yeah.
I'm saying sometimes you think the Lord is giving you lemons. And in fact, he's giving you big, beautiful titties.
So saith the Lord in this year of our Lord, 2026.
I want to know what you have to do to mistake lemons for titties.
Hey, you got another super chat here from Jay Down.
Hey Dan, thank you for the $5. I haven't paid you to call LO a C word in weeks. I'm going through withdrawals. Can you please indulge me? Here's the thing. I have previously called Laura a cunt. Has my opinion changed? No. However, I don't intend to continue calling her that because she has a crazy person threatening to sue me for it. Now, should I be able to express my opinion? Yes, but it would be inconvenient for the crazy person to attack me. So, unfortunately, I'm gonna have to pass on that one for now. I wish I could give you your $5 back, but I can't. So,
well, I'm not up for calling people names like that.
yeah,
I don't
you
need
never
a person. I would never. I mean, I'll tell you what. If you're my friend, I will call you names. If you're not my friend, I will not call you names.
Oh, I was being sarcastic. I've heard you call Blake Lively a cunt at least 4 times.
I might have been like 0.14 when I did that. 0.13 or 4, and it might have been. It wasn't jest. It wasn't jest. If I did say something like that, I was being funny and I made you laugh.
Well, we have to tone it down with the cunts now. You know, we don't need to show our cunts on YouTube anymore.
I'll do my best.
Yeah.
Oh, Jesus Christ. Yeah, I don't need to look. I'm a human being. Laura Owens is human. David Gingras is human. It's difficult for me to put aside my humanity and not feel empathy for the both of them. In spite of all the things that have happened, I still can see and recognize that they're human beings going through something. Whether or not I agree with their conduct or what they've done, I have no desire to pile on them in that way. I will comment publicly on their cases, and that's about it.
I have used some choice words and name calling, but in response to her or him attacking me directly or falsely accusing my friend of rape. How about that? So yeah, sometimes I have impulsive reactions to that, but consciously I'm not trying to cause any pain. You know what I mean?
Well, it is your First Amendment right to react in a derogatory way to things that you think are bad. And so there's nothing wrong with that, as we have done in the past, specifically with Blake Lively. But I believe that would be considered punching up and not down. You know, I'm not wanting to kick somebody while they're down.
I'm not even punching that lady. I just want her to leave me alone.
Oh, she's still bothering you?
Yeah.
Oh, what to tell you?
Mostly because she, keeps saying that she's a subject of a smear campaign, but it's not bothering me directly. Just, generally speaking.
Well, there you go. I've never gotten accused of a smear campaign with respect to her. I'm a little jealous of you and Cassidy. I haven't talked to Cassidy in the longest time. We were once doing a whole series on Alex Murdaugh, and we just forgot about it.
Oh, I thought you guys finished that.
No, we got 2 more episodes to do. Maybe I'll email her, say, hey, do you want to finish the Murdaugh thing? We covered his appeal, and that was it. Anyway, it is long past my bedtime, and I know it's past your bedtime. I think it's time to wrap it up. What do you say?
Sounds good.
All right, folks. That's all I got for you today. I hope you enjoyed it.
This cunt's going to bed. How about that?
Don't show your cunt.
I didn't make sure the guy got his $5 worth. I'm not going to call her a cunt, but I am one.
All right, folks. Y'all have a wonderful night. We'll see y'all next time. Be safe out there. Bye-bye.
Yeah, whatever he said. Bye.